Hello and good morning, everybody. My name is Abraham Hamra, and I'm a partner at Cohen and Tucker. Thank you for joining me today. We're just going to wait a little bit to have some more people join so they can hear this conversation that we are going to start today. Please feel free to share this with all your friends. We are going to discuss a very important topic today, and that's going to be employment law and how it relates with immigration status. I know a lot of people have questions in this regard. A lot of people are employed, are being asked questions to fill out verification forms, etc., etc. And so we're just going to wait a few minutes until a couple people join us. And we'll begin. So as I said, initially we're going to be discussing labor and employment law and how it relates to immigrant workers, whether they're undocumented, green card holders, regardless, but generally classified as immigrants. And we're going to discuss implications of different laws that help protect our most vulnerable population from being taken advantage of. And unfortunately, a lot of employers do take advantage of immigrants and of their statuses, and they think they can use it as a leverage, which they cannot. And so the purpose of today is really to empower you. It's to give you your rights, so you know your rights. And so feel free to share this video. Feel free to share this live feed. The more people that see it, the better it is. We will be talking about your rights. And so let's start with the employment verification process, also known as an I-9 verification. A lot of employers routinely ask employees that they're hiring to fill out an I-9 form. And so what is an I-9? Well, the federal government mandates that all employers must verify their employees' authority to work in the United States. And this mandate really comes from the IRCA, which is the Immigration Reform and Control Act, which makes it illegal for employers to knowingly employ undocumented workers. And so every employer has to comply with this provision and has to comply with the I-9 process. So they have to ask for, one, an identification, and number two, authorization of work. And so that could be a social security card with a New York State driver's license, for instance, or it could be a passport. But an employer cannot discriminate on which type of documentations you present them to verify their authority to work in the United States. But they can insist on you filling out an I-9. They can and must insist on that. Now, there's an issue, and let me highlight. Some employers routinely don't do the I-9 process, and they don't do what they're supposed to do. They'll hire people of all different nationalities, races, origins, etc. They may pick on their undocumented workers. So let's say an undocumented worker tries to assert a right at the workplace, complains, I'm not getting paid enough, or I've been harassed, or I've been discriminated against. And then the employer turns around and says, hey, fill out this I-9, I need it. And the employee or the undocumented worker says, no, I can't fill it out, right? The employer goes, oh, well, if you can't fill it out, then I'm firing you. I'll see you later. You're fired. Now, is he right that he needs the I-9 form filled out? Yes. But the only reason he asked for it was to dismiss or fire that employee. And so that is a form of discrimination within itself. So if the process isn't fair, if the process isn't equal, if the process is different for immigrants or people who look like immigrants than it is for people who look like Americans, that's an issue, and that is discrimination. Now, one important thing to note is you are protected. You do not have to fear that you're going to get fired if you make a complaint and there's going to be no repercussions for that firing, right? So a lot of undocumented workers have this fear, and it's a rational fear, right? They go, look, I've been taken advantage of at work. I've been discriminated against. I've been harassed. I've been underpaid. But what am I going to do? What am I going to sue them? They're going to kick me out of the country. And so, what I want to impress on you is don't think like that, because the reality is that you have the right to sue. You have the right to challenge these issues. You have the right to challenge discrimination. And your employer would be retaliating against you if, in response to your challenge, he or she decides to contact Homeland Security or ICE or whatever other government headquarters to report you or to cause you trouble because of your reported activity. That's a protected activity, and you're protected whether you have papers, you don't have papers, whether you're a green card holder, whether you're a citizen. You are protected. And it is important, as I said initially, to protect the most vulnerable population in the U.S., and that is really the undocumented workers, because, as I said, they routinely get taken advantage of. So let's talk about what an employer cannot do in an I-9, for an I-9. Your employer cannot demand that you show specific documents because of your national origin, ethnicity, immigration, or citizen status, race, color, religion, age, gender, or disability, or because of any other protected characteristics. So, for example, your employer cannot require that you show a document issued by Homeland Security because you are not a U.S. citizen. Or he cannot require a U.S. passport because you sound foreign and claim U.S. citizenship. He cannot refuse to accept your document or refuse to hire you because of an unfounded suspicion that your document is fraudulent. For example, your employer may not refuse to accept your U.S. passport because you have a limited English proficiency. Now, the employer can also not treat you differently. Equality. Remember, we spoke about this initially, how your employer must treat you as equal as everybody else. He cannot refuse to accept your document or refuse to hire you because your documents expire sometime in the future. Now, an employer cannot limit jobs, and this question gets asked plenty. Can an employer tell me, hey, I'm only looking to hire U.S. citizens? And the answer is no, unless that particular job requires a U.S. citizen. Very, very rare. So, in most instances, an employer cannot make U.S. citizenship a qualification for the job, as it is a form of discrimination. And so we spoke, just a refresher, we spoke about the I-9 process and how every employer is required to have an I-9 filled out, how every employer must accept whatever documents, if they're legitimate, that are presented by the employee, such as a Social Security, a driver's license, or a U.S. passport. You are protected as an undocumented worker under discrimination laws, under wage and hour laws, and that we want to encourage everybody not to take it. Don't take abuse. Don't take a beating just because you believe or you have a fear that, hey, if I bring up this issue to my employer, I'm going to get fired. Because the reality is there are laws that protect you. There are laws that protect your right to protest. There are laws that protect your right to complain about any illegal activity such as discrimination or sexual harassment or underpayment. I now want to transition into wage and hour claims. And this is an area that we get asked about tremendously. Unfortunately, this is an area in which employers sometimes feel that they can have leveraging power with the employee. And so I'm going to speak about the FLSA, better known as the Fair Labor and Standards Act. This is a United States statute, so it's a federal statute that protects employees And it is designed, it creates the minimum wage, right? And it also creates overtime laws, exemptions to overtime laws. Now, there are state equivalents to this statute, and that's the New York labor law. That is essentially the same thing as it's more strict than the FLSA, and if you're in New York, we're going to be using New York labor law because it has more protections than the FLSA statute when it comes to workers. And what's that more protection? It allows a longer period of look back, right? So under the FLSA, if you prove willfulness, you can only go back 3 years, as the statute of limitations is 3 years. Under New York labor law, you can go back 6 years to claim underpaid wages and to try to get some back from your employer. So, what is the FLSA? The FLSA determines the minimum wage. Just like the New York labor law and the Department of Labor, they formulate a minimum wage. Every employee, okay, is required to be paid in accordance with the FLSA and or with the New York labor law. Now, a lot of times we have undocumented workers that come in and say, listen, my boss is paying me a flat salary of $400 a week, but he's making me work 60 hours. Or somebody may come in and say, my boss is paying me an hourly rate, $10 an hour, $15 an hour, but I'm not getting paid overtime. I'm getting paid a straight rate, and I'm working 55, 60 hours a week. What do I do? And we encourage them at that point, listen, we need to explore your specific situation and see if you have a right to bring a lawsuit. The first question we get asked is, I don't have papers. If I bring a lawsuit, am I going to get kicked out of this country? And although I am not a prophet under any circumstance, I cannot foresee the future in that terms, and can Homeland Security in the future. The reality is, just because you bring a claim does not make you more likely to be deported from the country. Actually, you are protected because you've been taken advantage of. And so the question of whether or not you're even documented, at least in New York and the circuit courts in New York, is a question that is not allowed to be asked by the defendant. So for instance, if you're sitting in the middle of a deposition on a labor case and your employer asks you, hey, do you have papers? Or the attorney on the other side goes, hey, are you a green card holder? Or what is your U.S. citizen status? Or what's your immigration status in this country? That question within itself has been determined as being completely irrelevant in the context of an FLSA lawsuit. And therefore, the judges in the Second Circuit at least, have decided that that question is not admissible and cannot be asked. So who does the FLSA protect in this context, in the context of our conversation today? Well, it protects almost every employee. Now, there's a different type of classifications of employees. There's hourly employees, and there's salaried employees. Now, you cannot be a salaried employee unless you're exempt or your job is exempt from the FLSA hourly wages. So, for instance, a manager, he manages 2 or more people, makes authorities to decisions on hiring, firing. That person can be paid a flat weekly salary for any hours they work. But that person must be classified as a manager and must have managerial duties and supervise 2 or more people. Now, what are the salary qualifications? No, your boss cannot give you $500 a week, right? There are minimum almost like the minimum wage hourly, there's minimum salary qualifications for those exempt jobs as well. Now, that differs between the federal government and New York. So let me talk about New York a little bit. So just to give you a context of what that amount is in New York, that salaried amount for exempt employees, it is over $1,000 a week. Now, for most, there's other administrative exemptions. There are many other exemptions to statute. We're not going to go into those today. I can give you a whole lecture on these different exemptions. So let's kind of refocus the conversation on the hourly worker, on the non-exempt employee, on the worker that is supposed to be get paid by the hour, a worker that's supposed to be receiving minimum overtime and minimum wage. Let's talk about that classification under the FLSA. And so, if you're a deli clerk, a delivery person, a waiter at a restaurant, a cashier, a retail clerk, mostly any job that you can think of that's not administrative in nature, where you don't have authority making decisions, a job where you're not a manager, most of the other jobs are hourly paid jobs, or required to be paid by the hour. In New York today, in New York City, the minimum wage is $15 an hour. And your employer must give you a few forms when you first work. One is a pay notice, which is known as an LS-54 form. That form must be given to you at the beginning of any employment you receive. This form alerts you to what your set rate is. What are you getting paid by the hour? Is he paying you $10? Is he paying you $15 an hour? We need to make that determination. New York said, look, let's formulate this sheet, this LS-54, to give to employers so they can fill it out and notify their employees of their specific pay rate. And the pay rate is very important because it's going to essentially help us determine what the overtime rate should be should we work over 40 hours a week. And so that LS-54 form must be given to the employee, and it would naturally have the employer's name, when it was given, either at hiring or when there's a raise in the salary. Then it asks you for the rate of pay that the employee will be receiving per hour, any deductions that the employer may be taking, such as tip credits or meal credit deductions for restaurant workers, what day you get paid, how often you get paid. Finally, it asks for your name and what language you speak. And the language part is important because the LS-54 that you receive from your employer must be in English and in the language, your first language. So the Department of Labor has promulgated forms such as LS-54S, which is the Spanish and English, or LS-54C, which is Chinese and English, to help employers comply with the statute requiring notice of pay, a rate of pay. Now, once you start working on an hourly rate, your employer has a duty to continually keep records of your employment in terms of how many hours you worked, in terms of how you get paid. And that duty in New York expands to 7 years for safety. It's really 6-year statute of limitations, but most employers routinely hold it for 7 years. And so you're supposed to be clocking in and out, and there should be an accurate measure of how many hours of work you're putting into the job. Though at the end of the week, let's assume you work 50 hours that week, you then are supposed to be receiving a pay stub. The pay stub will have all the required information, and that's called a pay statement, which is also another requirement under the New York labor law, that every employee receives a wage statement. And that really summarizes how you got paid. It says your name, your information, your hourly rate, how much was your, they calculate the hourly rate for you so you can see the calculation. Then it goes into the tax deductions that they took out of the paycheck, to the end, the net pay of the check, and of course, attaching a check with it as well. Once you get paid, if that's how it worked, your boss is in compliance. But unfortunately, at the start of this, I said something. And that was, immigrants, and specifically undocumented immigrants, are usually targeted, unfortunately, because of their status. And employers feel like, hey, listen, I can pay them less. I can pay them under the minimum wage. I can pay them, I can refuse to give them overtime and just pay them straight time. And so a lot of situations in which we see our employees are coming to us and saying, hey, I've been paid $600 a week for the last 3 years, and my boss, I have to work 50, 60 hours a week at this restaurant. And so, they feel like they've been underpaid. An employer may say, no, well, they weren't underpaid. We agreed to the set number of salary. But that feeling that the employee had is right. They were underpaid. And that's because that's not how it works. An employee cannot just give somebody a set salary a week unless that person has been exempt from the FLSA statute. That employee, that job classification is an exempt job classification. So what do we do in that situation? How do we handle, what are your damages? And so let me revisit this topic in calculating your pay rate. If you were a worker who received a set salary or flat salary per week. And so what we have to start with, let's assume you were paid $600 a week and you worked 50 hours per week. What you do is you take the $600 and you divide it by 40, which is the first 40 hours. Because the law is going to assume something, and especially in the hospitality in New York, you have to calculate it this way. Hospitality and restaurant industry, they have to calculate it this way, the pay rate. And so this is how you calculate it. You take 600 divided by 40, because the law assumes that the $600 was used to compensate you for the first 40 hours of work. When you do that, you get $15 an hour. 40 divided by 600 is $15 an hour. So at least the boss has been in compliance with the minimum wage. But now, what the law is going to also assume is, wait a minute, there's an extra 10 hours at the end here. There's 50 hours a week that this person worked. We only divided by 40. What happens to those 10 hours? How are they calculated? How are they paid out? And so how the law calculates these 10 hours is quite simple. They take that $15 an hour pay rate, which we receive by dividing 600 by 40, and they multiply it by 1.5, which is times and a half, 1 time and a half, your standard rate. That gives you the overtime rate. So 15 times 1.5, you get $22.50, if my math is right. If not, I apologize. I'm an attorney, and we are not mathematicians by nature. And so if we take that the first 40 hours, right, the $15 an hour, and you multiply it by 15 times 40, you get 600. And then for the 10 hours, right, you work 50 hours a week and you receive $600. So you use 600 divided by 40, you get 15. You have 10 hours of uncompensated overtime. And so what they do is they take that 15, multiply by 1.5, they get $22.50 an hour of underpaid overtime. That $22.50 gets multiplied by the 10 hours, and that comes out to $225 of underpayment per week. Now, in all circumstances, if we can show willfulness, and that means that the employer had no good faith basis in not paying you in accordance with the FLSA, if willfulness can be shown, then you get liquidated damages, which is multiply that $225 per week underpayment by 2. And so you can see how quickly your underpayments add up. And that's legitimate. That's because you've been getting underpaid all these years, right? And if you work 3 years at $600 an hour, you're going to be owed a lot of money. And that is your money. And you have every right to demand it. And you have every right to pursue it. And just because you don't have papers or you're a green card holder and not a U.S. citizen or you don't feel comfortable, that it should be irrelevant. You should receive your payment. And when you sue in federal court for that, they will not ask you whether you have a green card, whether you're a U.S. citizen. That is an irrelevant conversation. You deserve to get every dollar of back pay. The only time, whether your citizen status, whether not your citizenship status, but your documentation status, so whether you're a documented immigrant or a legal immigrant or an undocumented immigrant, the only time that matters is when we're talking about damages for discrimination or for retaliation, which would usually award front pay, which means, hey, I could have earned an additional $5,000 if you did not retaliate against me. Your immigration status and those type of demands matters because you cannot get front pay because you wouldn't be authorized to work anyways in the United States. But other than those sorts of situations, or if you're not looking for front pay, your immigration status is irrelevant in actions. So we spoke about the flat rate worker. Now, there's another type of worker, the highly compensated flat rate worker. And when I say highly, I'm not talking about people who earn over 100,000. There's an exemption for that. But what if you worked 50 hours a week and you were paid $1,000? Do you still have a claim? And the answer to that is yes. And your claim is actually greater than it was when you were getting paid $600. Why is that? And that's because how we determine the rate of pay. Remember, we did the calculation. Instead of dividing 600 by 40, this time we'd be dividing 1,000 by 40. So you can see your rate of pay would increase to $25 an hour. The overtime rate would increase to about $33, $37 an hour. And so that multiplied by 10, those 10 hours, increase to $370 or $350 a week, and you divide that by 2 for liquidated damages, and now your underpayment is $700 instead of $500 a week. And now, as I said, in New York, we can go back 6 years, so the damages add up quickly. The beauty in all of this is that there's a ton of attorneys out there, including myself, that will handle your case on contingency without taking a penny, unless they win or actually receive a judgment or settlement on the case. And so this should encourage you not to stay quiet. If you're getting underpaid, speak up. Don't be afraid. Demand what is rightfully yours. This country protects you, whether you have documents or you don't have documents. You're not an animal. You're a human being, and you deserve fairness and equality. And I implore anyone watching this video that has any question whatsoever as to their personal situation at an office, contact me. Our number is 212-840-0050. We have the friendliest staff in the world. We'd be more than happy to speak to you regarding and answering any questions that you may have in regards to your working situation, your immigration situation. So the beauty of this collaboration in this firm is that you have your immigration attorney and then you have your employment and labor attorney at the same time. And so you'll be able to protect your rights and pursue your documents simultaneously. I thank everybody for joining me today. I hope I was not too boring, and I hope to see you in the future. Thank you, and have a lovely, lovely day.